Members, yesterday the Leader of the Opposition raised with me the possibility of a connection between the actions of MPs outside the House and the prescriptive rules of standing orders which relate to parliamentary proceedings. I received a letter from Tangi Utikeri asking if Standing Order 418T might apply in this case. That case being the circumstances under which David Seymour advanced a Land Rover up several steps of Parliament despite being told by organisers that they did not have permission to do so, and ultimately withdrawing once the security officer told him that it was the Speaker's decision. May I thank the many email correspondents who have encouraged me to take a range of actions, none of which are permissible. I suggest they accept that standing orders don't currently anticipate responses to this situation. This was the case in 2003 and it hasn't changed since then. Criminal law applies now as it did then, but I note that when a prosecution was brought against Shane Arden in 2003, the court said it was a waste of time and the proceedings were not carried on with. If standing orders are to be broadened to give the Speaker wider authority over MPs' activities that are not connected with the proceedings of Parliament, then it should be the Standing Orders Committee that fixes or first examines those possibilities and considers any implications from those changes that might enable some of what has been requested. If those changes are agreed by the committee, then it would be for the House to enact. I am in an interesting position of many expecting an action without a sound basis for that to be undertaken. I'm interested in the application of standing orders that relate to the parliamentary proceedings and MP privilege as it relates to those proceedings. In my opinion, it's not possible to prescribe broad enough orders that achieve both protection of privilege and prosecution of stupid. This may be something that the Standing Orders Committee is more able to clearly define. Accordingly, I'll seek to convene that committee in the sitting week of 3 to 7 March. The claim that Standing Order 418T might be applicable in this case does not pass scrutiny. It relates to orders made by resolution of the House, not administrative decisions of the Speaker. Members, I've received a letter from Ingrid seeking to debate under Standing Order 399 the decision by the Minister for Mental Health to reallocate funding to the Mental Health Innovation Fund. This is a particular case of recent occurrence for which there is ministerial responsibility. The big hurdle to overcome is whether the matter warrants setting aside the business of the House. Ministers sometimes make decisions that surprise officials and do not always act in accordance with official advice. It is a minister's right to do so, and they answer to the House for their decisions. I do not think the application makes out a case for this matter being sufficiently urgent to give it priority over the business on the order paper. The application is declined. I call on the Honourable Chris Bishop.
Thank you, Mr. Speaker. Next week,